2214 State versus Shepherd Eric Avala Jeepson. Could I have parties announced?
Violator State.
Pat Hancock for Mr. Jeepson.
And are you Mr. Jeepson?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same? Thank you. Are you the same Shepherd Jeepson who was placed on deferred adjudication in 2024 CR 2214 for the offense of evading arrest, detention with a vehicle on May 13, 2024 for a period of 8 years? Is that you?
Yes, Your Honor.
State?
Violation of condition number 1 on or about the 5th day of December 2025 in Fairfield, Texas, and defendant Shepherd Eric Avala Jeepson committed the offense of unlawful carrying a weapon in violation of condition number 1.
How do you plead to that? True or not true?
Sure.
In violation of condition number 1, on or about the 5th day of December 2025 in Fairfield County, Texas, the defendant Shepherd Eric Avala Jeepson committed the offense of driving while intoxicated in violation of condition.
How do you plead to that? True or not true?
Sure, yeah.
We leave it abandoned leaders to move on.
Any objections to the waivers?
No, Judge.
Did you understand by pleading true to violations of conditions 1 and 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, sir.
Knowing that, do you still wish to plead true to violations 1 and 1?
Yes, sir.
Court will find 1 and 1 true. Off the record for a moment. Excuse me, if y'all could whisper or behind the court reporter, please. You're talking too loud.
Please.
Deputy, is it okay to move them to maybe the back row? All right. All right, we're back on the record. Is there a proposed agreement?
There is, here are the United States motion, here alternate the conditions to include ISF 2 followed by ISP supervision and the admission interlock device. And then we are asking that this be run concurrent with probations in 2026 000781 and 2026 CC 000782, and the state will be taking into consideration 2025 via 48384.
I'm sorry, 48384.
Correct.
All right. Is that the proposed agreement?
It is, Judge, and I hope the judge, you'll recall, I think we were here last week, you had referred Mr. Jeepson to drug court.
Yeah.
So he had his interview, I think, this week,
Yeah.
and had an appointment set with Judge Glenn.
Correct.
However, during the interview, they asked him questions, and I think he was rejected because he admitted that he had sold some marijuana in the past. So I think he was honest to the point where he got rejected. But, you know, as we stand here today, Judge, I think when we came to ask you for a bond on an MTR, his dad was present.
Yes.
And his mom, and you had asked him if he had any mental health issues, and if he did, he needed to seek treatment. His mom and his dad sat with him, and in the interim between today and that first bond setting, Judge, he has met with a therapist. They made the diagnosis of some kind of PTSD. He had been shot in a incident some time ago, and they recommended some medication for him. Certainly is not a reason not to take into consideration the new offenses he committed, but I do think he would benefit from that cognitive track of ISF, Judge.
All right, and if you'll make sure probation has copies of that?
Yes, ma'am.
Okay.
So we would ask for you to go along with the recommendation, the ISF, if there's no other, if drug court is obviously not an option for him, but ISF, I think he's benefiting. He's 22 years old, Judge, and I think finally his parents and him are on the same page. He's got a 17-year-old sister that he wants to set a good example for, even after all these mistakes. So we're at your mercy today, Judge, and ask that you send it to ISF and keep him on for determination.
All right, did you hear what I told the last person?
Yes, ma'am. I heard
All right, so I don't know why they took the Scared Straight program off there, but they need to bring it back. Here's the thing. One, counsel, if you want to, you can probably try to lobby for him to be in felony drug court, even though he had the marijuana issue in the past. Because I really think that that would probably be the best place for him based upon the DWI and then based upon the mental health. So if you'll sort of talk to them, and I'll try to refer them
No, that'd be
back
great,
there.
Judge. I'll try to reach out to Judge Coleman.
Yeah. And if nobody has any objection, I'll send them an email and I'll include, I don't know if I have your email address, but is there any objection to me sending an email to felony drug court, just letting them know that it's of my opinion, which people can do what they want with my opinion, that based upon the mental health record that you've allowed me to review and based upon the DWI, felony drug court will probably be best for him because they have the diagnosis program.
We would be happy if you did that, Judge.
All right. So I'm going to give you the options that I gave the last person, right? You're on deferred for evading arrest detention with a vehicle. Range of punishment is anywhere 2 to 10 years in the prison.
Yes, ma'am.
All right. So you have a choice. Either way, you're going to go into custody today. Here are your choices. There are no other choices. One, I follow your agreement, but however, I'm going to add a referral to felony drug court again. I'll send them an email, have probation send an email, or I can revoke you and I'll sentence you to 2 years in the prison. Which do you prefer?
Not.
Okay. All right. This is what the court is going to do. The court will deny the motion and state your excuse. Alternate mean conditions to, we'll do a re-referral to felony drug court.
Yes, Judge, I'm sorry, I was not, privy to the conversation that we had. Were the certain circumstances already told to you?
Yes. So I think maybe if felony drug court is aware of the mental health issues that he has as well, maybe they'll accept him. I'm not sure. But his attorney said he's going to reach out to them. So we'll do a re-referral to felony drug court. And everything I'm saying right now is going to take place in custody. So there's a re-referral to felony drug court. If not accepted, then ISF, followed by ISP. This is to run concurrent with 2026 CC 000781 and 000782. Taking consideration 2025 PF 48384.
Judge,
Yes.
want to make the court aware that the ISF that we were recommending was for local ISF.
Okay, I'll put that in here. So that would be local ISF. There's to be ignition interlock. Can you raise your right hand for me, please? I'm sorry. That's okay. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Shepherd Jeppson.
All right. So is there anything else that you need from the court?
No.
All right. So before all this happened with the motion to revoke, were you in school? What were you doing?
I was in college all of last year.
Okay.
I was in spring semester attending a SAC community college
Okay.
for business and marketing.
Mhm.
And then I kind of followed through into the fall I finished up finals week, was the same week that this occurred.
Okay.
And I haven't been able to reapply, coming up into this spring semester.
All right. And then we'll waive the community service restitution hours if he obtains some type of higher level of education. All right. Anything else you need from the court?
No, man, I appreciate you.
Sure. Probation, is there anything else that's needed? All right, we can go off the record. Here's the thing. In this court, communication is key. If there's an issue, you need to let probation know about it. If you feel they're not addressing it, you can come to the court. That's what I'm here for. You understand? All right, good luck to you.
Thank you.
Court is calling 2023 CR 2434, State of Texas versus Daniel Fretwell. Can I have parties announced for the record for the state?
Hank Wilkins for the state.
Defense?
Catherine Wallace-Waller.
Are you Daniel Fretwell?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Fretwell, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Fretwell, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yeah.
Did you understand you're charged with the offense of possession of a controlled substance penalty group 1 gram to 4 grams? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yeah.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Fretwell, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison and there are no applications. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No such motions have been filed.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Your Honor, submit States Exhibit 1 in the attachments.
Your Honor, my client and I reviewed stage one. We have no objection.
Mr. Fretwell, State, you may be excused.
Thank you.
Mr. Fretwell, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, and laboratory reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments, and the court will review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
All right, does anyone know, because from what I read in the police report, it says that the vehicle was stolen?
I'm still charged. He has been making payments on it.
I was buying it, but I didn't know it was stolen. I was making
And so
payments.
they never went further on
Okay.
it.
All right, anything you wish to say, Mr. Fretwell?
No, man.
All right, Mr. Fretwell, it appears that you have a drug problem. So if you want, I can refer you to the therapeutic community. It does not increase the length of time that you are in prison, but they may be able to help you with your drug issue.
Your Honor, Mr. Fretwell, yes, he does have a drug problem. He picked up a case pending this one
Mhm.
in Williamson County. He's already been sentenced to 3 years on that. He was in TDC and brought back to handle this case.
Okay.
So he's already been,
I've been in there for 8 months.
and so we believe he is getting some treatment and he's looking.
Are
at
you receiving
parole.
treatment at the prison?
Yes, ma'am.
Mhm. All right, then I'll put therapeutic community. I don't want this case to stop you from getting treatment. Court will find you guilty, sentence you to 2 years in the prison, give you credit for any time served, and the court will recommend the therapeutic community. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you, Mr. Fretwell?
52,
All right, how long you been using?
a long time.
All right, so here's the thing. You are going to have to make sure that you stop using. I read in the police report, you were talking about your mom. Is your mom still alive? All right, and I'm sure your mom loves you, right? Stop breaking her heart. So when you go to the prison, you're saying that they're already giving you treatment there. Continue with it. Be actively participating, internalize it. When you are released from prison, I know people are excited because they're released. You're probably going to run to your mom, tell her how sorry you are, and it's never going to happen again. You got to remember prison. You got to remember your treatment. And the first thing you need to do when you get out of prison is go to an NA or AA meeting and keep it up. And if somebody tries to dissuade you from going, and by that I mean, if you have a scheduled standing appointment with AA and they say, well, let's just stop and have lunch. You can do AA tomorrow. You can do it this afternoon. That person, you got to cut them loose, because everybody from here on out who's in your life, when you tell them you have an AA or NA meeting, and if it's at noon or 8 a.m. every day, that person should be saying, oh, do you need a ride to your class? Not, let's just stop and have breakfast. You can go late, because that causes you to backslide. The last thing you want to be is the person in Bexar County and somebody's trying to identify your body, and then they tell your mom that you passed. You understand? Last time